Hello everyone, and welcome to today's webinar. It pays to be covered, constructing the best coverage for you. Before we get started, I have a few housekeeping items. The default audio setting for the webinar is to listen through your computer speakers. If you dial in, please make sure your phone is on mute. We will have a Q&A session at the end of the presentation. You may type your question in the questions pane of the control panel at any point during the presentation. We will address these during the Q&A portion. I would like to introduce our presenters, Catherine Henry and Amy Garber, both from our Policyholder Insurance Practice Team. Catherine is a partner in our Bradley, Washington, D.C. office, and Amy is an associate located in the D.C. office as well. Catherine, I'm handing it to you.
Thank you, Morgan, and welcome everyone to today's webinar where we're going to discuss insurance terms and conditions relevant to construction contracts. So just to give you some sense of where we're going in this webinar today, we are going to start with the American Institute of Architects, the AIA, form insurance language that is available, and many of you may use it in contracts that you are entering into. We're going to use that as a premise for our discussion, and we're going to drill down into a particular aspect of those insurance requirements, the commercial general liability insurance obligations imposed upon the general contractor under the AIA form. Now, those obligations require additional insured status, and we'll talk about it for the contractor and the subcontractor, actually. So we will talk about additional insured endorsements that are typically used in this context, how those have expanded and contracted over time, and how that can impact your contractual obligations. And at the end of the day, bring to mind the importance of making sure that your contract terms, including the AIA form and anything else that you add to that form, like an insurance exhibit, comport with your risk allocation and insurance requirements, and also comport with the available insurance. Now, Amy is going to talk about the AIA forms themselves. We'll walk through those first before we turn to the additional insured endorsements that are relevant to these insurance conditions in the AIA form. So I'm going to turn this over to Amy now. Amy?
Good afternoon. There are several organizations that exist that, in addition to the American Institute of Architects, which we will focus on today, which put forth standard forms for contractors to use, and contractors and owners as well, basically to alleviate some of the complexities in construction contracts. Now, as you know, some of these might not always be applicable to every project, but the forms are a good place to start. So the AIA documents have general conditions in a document called the A201-2007 General Conditions, and that's what we'll focus on today. These provide the most detail for the framework for insurance coverage as it relates to construction contracts. One thing to be mindful of is that these standard forms are revised every 10 years. So the next revision is coming up. It's in 2017. So you'll want to become well-versed in those terms, as they may appear in, they will likely appear in contracts that are entered into after 2017. Aside from the general conditions, the AIA documents have standard agreements for different particular types of construction contracts. Here we have an example that is the standard form agreement between an owner and contractor, and this particular contract is where the basis of payment is the cost of the work plus a fee with a guaranteed maximum price. But as you can see, this is the insurance section, which is pretty sparse and refers right back to the general conditions, the A201-2007 document, and has a blank basically where the insurance that is particular to that project can be inserted. So one of the things to keep in mind is that the best practice is to include an exhibit to the contract that contains the detailed insurance provisions, because again, the framework that is laid by AIA is only in the general conditions, and as we'll discuss, it's not necessarily enough. So here are the general conditions, Article 11, and Article 11 encompasses insurance obligations for the owner as well as the contractor, and the goal is to follow the risk of the project. So the liability that the owner will face, the insurance provisions of the AIA track liability that the owner might face, and likewise the contractor in its own insurance obligations in that agreement. We're going to quickly discuss what the owner's obligations are in the AIA general conditions, but these can be quite comprehensive when you get into the meat of it, and we will be having a much more detailed presentation that focuses on these owner obligations later this year. But the 4 categories of insurance for owners in the AIA general conditions are the quote-unquote usual liability insurance, and that's the commercial general liability policy that the owner already has in place. Then there's builder's risk insurance to cover property damage, and then there's boiler and machinery insurance and loss of use insurance. Now the contractor's obligations, which we will focus on today, are commercial general liability insurance, workers' compensation insurance, employer's liability insurance, and business automobile liability insurance. And again, we are going to be zeroing in on the commercial general liability component. So here you see Article 11, which governs the contractor's liability insurance requirements. And to call your attention to some of these specific forms, so point 3 and point 5, claims for damages from bodily injury and property damage, are typically what you'd see in a standard commercial general liability agreement. Also typical to a standard commercial general liability agreement is personal injury coverage, which is basically personal advertising injury. So that's liability arising out of the contractor's advertising type activities, something like a defamation claim, slander, libel, invasion of privacy, things like that. Then we have another term that is also standard to the standard commercial general liability form, which is claims arising out of the contractual liability of the contractor. Now the final piece of this is claims for bodily injury or property damage arising out of completed operations. Completed operations coverage is not quite as standard, but we're going to talk about this in more detail and talk about how it can be very important to ensuring broad enough coverage. And this slide just summarizes those 4 categories of liability under the commercial general liability policy. Now, the subcontractor is also going to have insurance obligations in a construction contract. The AIA document A401-2007 addresses insurance in largely the same way as the agreement between the standard agreements that the AIA puts forth for contractors and owners for prime contracts, and that is to say it is not very informative. It requires the subcontractor to purchase and maintain insurance, and then it has those specific provisions. And again, we recommend having an exhibit with a more robust terms for the insurance. One thing to keep in mind about the standard form is that the subcontractor, like the subcontractor, is required to add other parties as additional insurers. It's required to add the contractor and the owner, and some other parties as well, but we're going to focus on the obligations as they relate to adding the contractor and the owner. And this can go upstream depending on what level of the contract you're in. So here we have a comparison of the additional insured provisions in the AIA general conditions that relate to prime contracts and as they relate to subcontracts. And you can see the subcontractor's obligations flow down and are similar to the contractors, which flow up to the owner. Now I'm going to turn this back over to Catherine to talk about additional insurance.
Thank you, Amy. So what do we mean by additional insured? You saw additional insured referred to on that previous slide and found in both the AIA forms. An additional insured is an entity that is added as an insured on a named insured's policy. The additional insured is insured for liability arising from the named insured's negligence. And the benefits for the additional insured, of course, is it's getting coverage, not paying a premium for it. It has no responsibility for any deductibles or self-insured retentions on the named insured's policy, and its own policies will not be eroded. The named insured's policy could be eroded, however, obviously if there was a liability that would protect the additional insured. So the additional insured and the named insured would be sharing those limits. We're talking about this rather abstractly, and an easy way to think of it would be, the relationship between a contractor and a subcontractor and an owner. This next slide helps us with that. So this is keyed off of the AIA form requirement. So let's start at the bottom. You have a subcontractor who's required to have general liability insurance by the subcontract between the subcontractor and the general contractor. You see at the bottom of your screen, the green arrow shows the requirement of the subcontractor. Likewise, a general contractor is required to have general liability insurance under the prime contract, which is your bottom green, your first green arrow, and then above that, that same prime contract requires the owner to maintain its usual liability insurance. So that's the premise of the AIA forms. Now, what does the AIA form do as to additional insured? Well, first, it requires the general contractor to name the owner as an additional insured. So that's our first red arrow. Second, it requires a subcontractor to name the general contractor as an additional insured. And finally, it also requires a subcontractor to name the owner as an additional insured. So the two forms that Amy talked about earlier today, when read in combination, require this type of additional insured structure under these various policies. So how do you do this? How do you comply with this requirement, whether you're a GC or a sub, to ensure that there's additional insured coverage? And just go back for a second, you see the owner has no additional insured requirements under the AIA standard form, only the GC and the subcontractor. So how do you do this? There are two main ways to do it using ISO forms. ISO are Insurance Services Office forms. They're standard forms with numbers and codes and dates of publication. They're commonly used in the industry. They have, and they're defined. Everyone knows what you're talking about. So we're going to use those for the next part of our discussion, just like we use the AIA standard forms to describe the contractual relationship. And we understand, of course, that insurance policies can be manuscripted or individualized, but we're just going to focus on the ISO forms that are available. So using the ISO forms, what are your options to comply with your additional insured requirements? There are two main ways to do this. First, you can have an endorsement that specifically names the additional insured. It schedules that entity by name, Prime Construction Company. That name is put on the endorsement and that entity is identified as an additional insured. The second and somewhat less cumbersome way is to have what's called a blanket endorsement. A blanket endorsement names as additional insured a category of entities. And there are two types of blanket endorsements, two blanket endorsements typically used in construction contracts today. One has a privity requirement and one does not. By privity, we mean that one requires the additional insured to enter into a contract directly with the named insured, such as the prime contract, the subcontract between the subcontractor and the prime. contractor, the general contractor. And another type of blanket endorsement does not require that direct contractual relationship. So let's look at these a little more specifically. This first example, a CG 2010-0413, let me just take a moment to explain these numbers if you're not familiar with them. These are the ISO numbers. CG stands for Commercial General Liability. 20 is the category of additional insured. 10 is this particular form number. And then 0413 is the month and year in which this particular one was promulgated. And it was promulgated prior to this under another year that would have the same number. That's what those numbers mean in the upper right-hand corner. So here is a endorsement. This is not a blanket. This is a specifically scheduled endorsement. And you can see the box is blank there. And that's to be completed with the name, for example, of Prime Construction Company. So Section A says who is an insured is amended to include as an additional insured the entity listed here in this box for the named insured's negligence in performing operations. So this is a specific scheduled additional insured endorsement. Now here is the standard blanket additional insured endorsement used in construction context for owners, lessees, or contractors. This is the 2013 version. You can see the 0413 up there. That means this was promulgated in April of 2013. This endorsement is a blanket endorsement. It provides additional insured status to a category of entities. And the category are owners, lessees, or contractors when, and you can see the yellow box there, you and such person or organization have agreed in writing in a contract to insure that person or organization. So for example, if you are the prime contractor and you have a prime contractor and a subcontractor, and in the subcontractor agrees to add the prime, the general, as an additional insured, the GC would be an additional insured if this endorsement was added to the subcontractor's policy. And again, this applies to operations, and we'll talk about that a little bit later. Now, this is another version of an additional insured blanket endorsement that was first promulgated in 2013. This is a new endorsement. And this endorsement is designed to capture a downstream party's obligations to add an additional insured that is upstream but not in a direct contractual relationship. So the example here would be that subcontractor AIA form that Amy spoke about earlier. In that AIA form, the subcontractor is required, in that subcontract, remember, it's between the subcontractor and the general contractor. That contract requires the sub to name both the GC and the owner as additional insureds. Well, clearly, under the previous form, the general contractor is an additional insured because the contract is between the sub and the general. But the previous form doesn't refer to a party, the owner, who's not a party to that contract. So this new form addresses that potential gap in coverage by saying that any other person that you, the named insured, have to add as an additional insured under the contract that we're discussing in one is also insured. So let's be very, just talk about this concretely. So in our example, we've got a subcontractor who has a contract with a general contractor. The subcontract says you must name the GC and the owner as additional insured. The owner, the GC gets named under 1 of A1. The owner is covered under 2 of A1 if you have this particular additional insured form 2038 as opposed to the previous form. So it provides automatic additional insured status to a contracting party that's not in direct contractual privity with the named insured. Now, here it is in a comparison of the two. You can see CG 2033, the contracting parties additional insured, and 2038 adds this second paragraph, anybody that you're supposed to name as additional insured by virtue of the contract at issue is also an additional insured. Now, while this seems fairly clear, Amy's going to explain to you, describe to you a case involving 2033, not 2038, where the court grappled with the potential coverage gap because of this privity requirement. So let me turn this back over to Amy.
So in First Mercury, this case involves building of a plant structure at Yale University. So there was a prime contract between Yale University and the general contractor called Shawmut. Now Shawmut had a first-tier subcontract with Shepherd Steel. Shepherd Steel, in turn, subcontracted with Fast Track. Then there was a steel collapse at the site of the project, and several Fast Track employees were injured and or killed. So as you can see by the black lines on this chart, the Fast Track employees and their survivors sued the general contractor and the first-tier subcontractor for negligence. Now those two entities went back and tendered the defense to Fast Track's insurance, arising the argument that they were additional insureds on that policy. Now here's what the additional insured endorsement said on that policy. As Catherine mentioned, it had the older language that arguably required privity, where you and such person or organization have agreed in writing in a contract or agreement that such person or organization be added as an additional insured on your policy. Going back to this chart, there was really no argument that the first-tier subcontractor, Shepherd Steel, was in privity with Fast Track and therefore could be an additional insured on the policy. The second-tier subcontract required Fast Track to add Shepherd Steel, and Shepherd Steel was named in the schedule of the additional insured endorsement, and it was actually named there as Catherine talked about that endorsement where you can actually put the name of an entity. So there was no real argument over that. The argument was whether Shawmut, the general contractor, who had no direct contractual relationship with Fast Track, could assert additional insured status under that endorsement on the policy. What the court did was take a broad interpretation. They considered both the subcontract and the lower tier subcontract to hold that there actually was additional insured status for the general contractor, despite the fact that there was no privity with Fast Track. And the way it did that was, going back to this graphic, the contract had flow-down clauses. So Shepherd Steel, in its first-tier subcontract with Shawmut, was required to require its own subcontractors to add the general contractor as additional insureds. And because that requirement flowed down from the first-tier subcontract into the second-tier subcontract, where Fast Track was required to add both parties, the court said, looking at these two contracts together, both the general contractor and the first-tiered subcontractor could be additional insureds. The court went even further, and they said that this endorsement didn't really require privity because it required that the parties agree in writing in a contract. It didn't require that they agreed in the same writing. So because the first-tier subcontract had an agreement to add the general contractor as an additional insurance, and then in the second-tier subcontract, Fast Track agreed to add both parties as additional insureds, there was coverage for both parties as additional insureds. Now, a word of warning about this case is that cases are all over the map in holding whether there is privity or not, and it depends what jurisdiction you're in and what the court, how the court interprets the policy language. So if you can get the endorsement that has the broader no privity requirement, that is highly advised rather than fighting this out and seeing how the court would resolve any ambiguity, because it truly could go either way. Now I'm going to turn it back to Catherine to talk about the completed operations requirement.
Thank you, Amy. Earlier we focused on the operations language, and we also saw a reference to completed operations here in Article 11 of the AIA form, and it's highlighted here for you, point 7. The contractor is responsible for maintaining coverage for claims for bodily injury or property damage arising out of completed operations. And what are completed operations and what are ongoing operations? All right, so ongoing operations are the operations during the course of construction. So your general liability policy covers bodily injury and property damage and those other coverage grants we discussed arising during the work. But this requirement says we also need coverage for completed operations. Completed operations coverage provides insurance coverage for liability arising out of the work that occurs after the work is complete. And a simple example would be constructing a commercial building and installing steps in that building. And let's say the steps are improperly installed in some way, but the building is finished, the operations are over, the operations coverage is no longer available, but 6 months later, a customer coming into the building is injured on the improperly constructed step and sues. The customer argues the liability arose because the step was improperly constructed. Well, that's something that happened during operations, but the claim doesn't come in during operations. It comes in after operations are completed. If you have completed operations coverage, then that claim can be addressed. Now, we did not focus too much on this when we were looking at these forms. Again, this is the first additional insured endorsement form we showed you earlier, the 2010, that schedules a particular entity as an additional insured. You can see who is insured is amended to include anybody named on the schedule for the named insured's acts or omissions or those on its behalf, such as the contractors, subcontractors. But you see this limiting language in the performance of your ongoing operations. So this endorsement does not insure the additional insured for completed operations coverage, doesn't provide it. This is 2033, the first blanket endorsement that we discussed. It too, crafted slightly differently but with a similar impact. A person or organization's status as an additional insured under this endorsement ends when your operations for that additional insured are completed. So both of these apply only to operations 2010 and 2033. So if your contract only requires these, you won't have completed operations coverage. You won't be comporting with the AIA requirements. Here also is 2038, which has an additional insured requirement, and I believe it too has the additional insured during the operations only. So what do you do? How do you deal with this? Fortunately, there is yet another ISO form, ISO CG20, again 20th additional insured category, number 37. And you can see by its title, additional insured owners, lessees, or contractors completed operations. And this is a scheduled endorsement, just like the scheduled operations additional insured endorsement where you name by entity rather than by category. It's not a blanket endorsement. And you can see here in the call-out language, who is an insured is amended to include as an additional insured in this case we're focusing on entities. Entities shown in the schedule for bodily injury or property damage caused by the named insured's work at whatever the location is, and included in the product's completed operation hazard. The product's completed operation hazard is a hazard that is addressed in the CGL policy, and coverage is excluded for that unless you have completed operations endorsement. But this is how you get that completed operations coverage. It's specifying this form, or this form or its equivalent. And this is a quick side note. If you're doing your insurance exhibit to supplement the AIA requirements, we recommend listing the form and the year if you want a particular year, because these forms do vary by year, and you don't always have to use the most current one, and then say that form or its equivalent. You have to give yourself some room in case the form isn't available or something changes, but that gives you a greater level of specificity, and you understand better what it is that you're requiring, or if you, the entity providing the insurance, what you are providing. Now, if you look at the subcontractor's obligations in the AIA document that Amy discussed earlier, the 401 document, you will see in 13.4 the reference to the subcontractor's requirements for CGL coverage. This one states that the subcontractor shall provide additional insured coverage for the contractor and owner, architect, etc. during the subcontractor's operations. See that in 1? During the subcontractor's operations. So this is an operations requirement. And then 2 at 13.4 says the subcontractor shall name the contractor as an additional insured during completed operations period. So this form does not require the sub to name the owner or the architects as insured after operations are complete. So just beware of that and think about what it is that you want to have or what you're required to provide under these forms, because the completed operations requirements differ amongst the parties. Now, Amy is going to talk to you about yet another case example that grappled with completed operations.
The Woodward case involved a condominium project on the Mississippi Gulf Coast where the general contractor was named as an additional insured on the subcontractor's policy. So you have the prime contract between the owner and the general contractor, and the subcontract between the general contractor and DCM, which was the concrete subcontractor. Now, the building was turned over to the condominium association, and the condominium association, as you can see by the black lines in the chart, sued both the owner and the general contractor for certain defective work and property damage on the project. What came out in the allegations was that the main cause of the defect was that the concrete subcontractor allegedly had not built the foundation plans in a way that matched the specifications and plans on the original project. The general contractor tendered its defense of the lawsuit to the subcontractor's insurance, and the subcontractor's insurance company said no, this arose out of the completed operations of the project, and we will not accept the defense. And so this endorsement had an exclusion which said that the work that the coverage would not apply to property damage that occurred after the covered operations has been completed. So this accomplished what Catherine had discussed in some of the endorsements that only covered the ongoing operations of the subcontractor. And going back, you can see that the subcontractor's insurance purportedly added the owner and the general contractor as additional insured, but the issue is whether the general contractor could be added to that. Now, the district court, the trial court in this case, said that the insurance company did have a duty to defend the general contractor, but the Fifth Circuit Court of Appeals reversed the case. They said there could be no coverage on the subcontractor's policy. what the court acknowledged was that it's possible that after the project is complete, there could be a claim that did arise out of the ongoing operations of a party, and in that case, the endorsement would apply. But here, the exclusion applied because the failure to build the foundation piers on the building according to plan only arose after the building was complete, and that was when you can see that the defect was related, that the defect did not match the plans of the original project. And so the court found that the breach necessarily arose from the completed operations and quite logically found that it did so and denied coverage. Now, in contrast to that case, we have a case in New Jersey where there was a snow removal contract. The contractor entered the contract to remove snow on an as-needed basis, as would need to be the case in a region where there are snowstorms, but it's not snowing every single day. And so there was one period where there was snowfall, and the contractor removed the snow, and that portion of the work was complete, and somebody slipped and fell and sued for personal injury. In this case, the court found that what happened was actually part of the contractor's ongoing operations. Rather than looking at the little piece of the contract that was complete when the injury occurred, the court looked at the overall contract, which was actually still in place and not complete, and found that because the liability arose out of the contractor's ongoing operations as it related to the overall contract, there could be coverage under that additional insured endorsement. Now, the best way to avoid a Woodward situation is to just get the completed operations coverage. If you're the upstream party in a contract, the owner contracting with the contractor or the contractor contracting with the subcontractor, make sure that the construction contract specifically requires that additional insureds are granted completed operations coverage. If you recall the language that Catherine was talking about in the subcontract form, she pointed out how the form does not require that additional insured status as to owners be due to the completed operations. And if you want to avoid the fight over those potential ambiguities, it's important to make sure that the construction contract specifically provides for that. Now I'm going to turn back to Catherine again to talk about a potential coverage reduction in the endorsement.
Thank you, Amy. All right, so we have been using these additional insured endorsements to talk about the coverage and how to comply with the AIA requirements that Amy outlined. And one of the ones we looked at, of course, was the 2033. This is the 2004 version of 2033. Again, this is the blanket insured endorsement that includes the privity requirement. And you can see 0704. This was promulgated in July of 2004. This particular endorsement provides that the insurance available to the additional insureds, the most we will pay on behalf of the additional insured is the amount of insurance required in the contract or available. Oh, I'm sorry, I got ahead of myself. Let me go back here to 2033-04. The 04 version doesn't have any reference to limits in it, any reference to reduction in limits. So this is 2033 as in July of 2004. Now, what happened is in the April 2013 version of this endorsement, the same endorsement, but it's the most recent version, it's imported a limitation, a financial limitation on the availability of coverage. Whereas the 2033 2004 version did not have a financial limitation, the 2033 2013 version does. And you see it here in C. With respect to the insurance afforded to the additional insurers, limits of insurance, the most we will pay on behalf of the additional insured is what's required in the contract, number one, or what's available under this policy, number two, whichever is less. So if the contract requires less than the policy provides, under this endorsement, the additional insured gets the lower amount. Now this is 2038, and again, this is the blanket endorsement that does not require privity. You remember it had the new provision that said that if another contract requires you to name someone as an additional insured, they're additional insureds. This one too, which was first promulgated in April 2013, so it's new, contains the same limitation on financial limits. The most we will pay on behalf of the additional insured is the amount of insurance required by the contract or whatever is available in this policy, whichever is less. So if the contract requires less than the policy provides, the additional insured cannot access the limits above the contract requirement. Before 2013, that limitation wasn't there. So a contracting party named as an additional insured, by fortuity, might have access to more insurance than that additional insured required in the contract. You might say, well, that really, it doesn't matter that much. We know what we're asking for. But it actually does. It can have an impact on you in a contracting relationship, and here is how. Here's our example. We have a contract requirement that requires, we'll say this is a subcontract. It requires a subcontractor to provide $1 million in primary commercial general liability coverage and $5 million in excess, in which it names the general contractor as an additional insured. So this is the first part of complying with the AIA form. Now let's suppose that subcontractor is a large company not comfortable with those low limits and itself carries $2 million primary coverage and $10 million in excess. So it's got twice what's required by the contract. That sounds great. Now let's assume we have a liability arising out of the subcontractor's negligence, subcontractor being the named insured, but the liability is placed in part on the general contractor, who is an additional insured. And the case is settled for $6 million. Will the general contractor, the additional insured, be insured for the full $6 million? Because that's what was required in the contract. The answer is no, not necessarily, because the subcontractor's policy under this endorsement that we've just been looking at, which says that whichever is less, whatever's required in the agreement or what's in the deck page, whichever is less is all you get. The contract we've just talked about only required $1 million. So all the GC can access on the primary is $1 million. There's another $1 million remaining, but it's not being tapped because the additional insured can't access it on our scenario, in which case the additional insured also cannot access the excess unless the excess has a drop-down provision. Now, obviously, if there was other liability that would exhaust that $1 million, that additional $1 million, you'd be fine. But if there wasn't, you have a coverage gap, and without the right drop-down language, the general contractor never reaches the $5 million in coverage. So this really matters in thinking about your contract requirements. Now, in addition to coverage reductions in these new forms on limits, these new additional insured ISO forms, also coverage reductions in terms of scope. This is the 2013 version of 2038, which again, it's the blanket additional insured without the privity requirement. It contains two components, only applies to the extent permitted by law, which seems kind of self-explanatory, but most importantly, B will not be broader than that which you're required by the contract or agreement to provide for that additional insured. So whatever your contract with the additional insured requires is all you get no matter what this policy says. So how could that matter? Well, here's an example. Let's say that your construction contract doesn't require completed operations coverage for the additional insured. But let's assume that the downstream party, say the subcontractor, procures completed operations coverage. won't matter. The additional insured cannot access the completed operations coverage because the contract itself restricts the scope. Here's another example. Contractual indemnity. This is an indemnification provision in the AIA form. We're not going to really, comment about, the scope and whether this is sufficient for any particular contract. We commend you just to look at it and make sure that you're comfortable on your exposure. But what's important is that this indemnity requirement, or whatever indemnity requirement you import into your contract, will limit the available coverage. So the coverage will only be as broad as limited by applicable law, and this addresses the sole negligence question, where states prohibit one party from insuring another for its sole negligence. That's one, but more importantly for our purposes too, the contractual indemnity obligations that the named insured has to the additional insured. So all you're going to get under the additional insured endorsement is whatever this form says, or the language that you have in your particular contract. There's another example. Primary non-contributory endorsement downstream policy. This is another additional insured endorsement. You can see there the number 20, CG20, means additional insured. It's another one promulgated in 2013. That's your 0413. This endorsement talks about the relationship between the various policies that might be available. And remember, in our example, we had the owner with its usual liability insurance, the general contractor with its CGL requirements, and the subcontractor with its CGL requirements. This particular endorsement ensures that the policy where the risk is supposed to lie cannot access the other parties, the counterparty's policies, to share the risk. So let's use an example of a subcontractor. You're using the AIA form, and the subcontractor must provide insurance coverage to the contractor for liability arising out of the sub's negligence. If this primary and non-contributory endorsement is required and on the sub's policy, the subcontractor's insurance company cannot access the general liability coverage that the contractor bought as required under this form. And it does that by saying that this insurance is primary and will not seek contribution, in other words, will not seek dollars from any other insurance available to an additional insured, in our example, the general contractor, provided that it's a general contractor's insurance, that's a reference to the name insured, and you have agreed in writing in a contract or agreement that this, being the subcontractor's insurance in our example, would be primary. It would not seek contribution from any other insurance available to the additional insured. This, I don't believe, is in the AIA form. If it is, that's great, but if not, it's something you should be cognizant of, and that we have these limitations on scope and ways to expand them. Now, in our example, starting with the AIA form, again, we refer to the usual insurance requirements, usual liability insurance for the owner. The standard CGL policy will have other insurance clause that says that that policy will be excess over the other valid and collectible insurance. So going back to our subcontractor's policy, let's just presume the subcontractor has named both the owner and the GC as an additional insured, and it has this endorsement on its policy. The owner has its insurance with this other insurance provision. There is no sharing of limits in this circumstance. The subcontractor's policy will respond to protect the owner for the sub's liability. The owner's policy does not respond until the sub is exhausted. So that is another point that you want to think about and address in your terms and conditions under the AIA forms when you're focusing on general contractors. General liability insurance and your general contractor. So what have we done here today? What we've done is we've focused on a couple of AIA forms as a framework, and looked at the insurance language contained in those forms, which you saw is fairly general, not very specific. We drilled down to the commercial general liability obligations imposed on the contractor in particular, as opposed to those imposed on the owner and on the subcontractor. And one thing I would mention, if I didn't mention it earlier, remember that the sub and the GC both have additional insured requirements. The owner does not under the AIA forms. Then we've looked at how the additional insured endorsements that are available to implement these insurance requirements expand and restrict coverage depending on the form that you use, and pointed out the importance of aligning your actual contract with the insurance policy, particularly to be mindful of those gaps. So what we would urge you to do if you're involved in a contracting relationship and in the construction context or in any other context where insurance requirements are placed, if you're using an AIA form, pay close attention to the form you're using and your contract language. Make sure your contract language matches the policy or the coverage that you see. Make sure that the coverage provided by the additional insured is as broad as the form provides, and don't get tripped up on those narrowing of scope endorsements that ISO has added that provide additional insured coverage but narrow the scope. To ensure that this is done, there are a couple of ways. I know that commonly in a construction context, parties ask for certificates of insurance, and I'm sure you've heard in other webinars that I've said it myself, these certificates of insurance are not binding. They don't provide insurance. They're really not evidence of insurance. They will not provide you protection. This is always a relative bargaining position as to what a particular contracting party can get. But if you can get at the minimum the particular policy endorsements, if you can see those, the ones that are specified in the contract, that would be ideal. Even better yet would be to see the entire policy. But again, it's always relative bargaining power, and some players will not provide even a certificate of insurance anymore. They only provide memoranda of insurance. So we recognize that it's a bargaining power issue, but at least to the extent you specified in your contract, you're better protected, even if it ends up being a claim against your counterparty. And then the final point is that the AIA form is a super place to start. It's a great template, but it doesn't stand alone on insurance. You need to add your own insurance requirements, being mindful of where you want your risk of loss to be allocated. So we thank everybody for their attention today. Again, as Amy mentioned, we are going to come back and address this from the owner's perspective in a future webinar. So I'll turn it back to Morgan now.
Thank you, Catherine and Amy. We're now going to begin answering questions submitted during today's presentation. We've received 2 questions. So question 1, what are other parties that contractor or subcontractor may be required to add as AI?
Thank you, Morgan. The AIA form itself actually mentions architects. Let me see if I can find that form. I have to go back just a little bit. Back to the AIA form. It's way back here. Yes, here we go. 13.4. Looking at the subcontractor one by example. The contractor, the owner, the architect, and architect consultants. And I believe another one of the forms refers to anybody for which the contractor is responsible. I think that's what the other form says. So those are other parties that are actually required by the form to be added as additional insurers.
Great. Thank you, Catherine. Next question. How long should you require the completed operations coverage to be?
That's a great question, and I'm sorry I didn't mention that. We talked about completed operations endorsement and the requirement that the subcontractor provide completed ops to the general contractor. And this is to cover for liability that arises out of the contracting party's negligence that occurs after operations are finished. How long should that period be? In looking at contracts, I've seen all sorts of time periods. The default that we recommend is to look at the governing statute of limitations for the potential liability and to have your term be at least that long. So if it's a tort liability, a 2-year term, depending on the state, or it might be 6 years, depending on the particular state, so that your completed operations coverage is in place during the time period in which a third party can bring a claim alleging that the construction itself was defective in some way and led to an injury. So that's the best way to do it. You want a long enough period to cover most claims and protect most exposures.
Wonderful. Thank you, Catherine. Again, thank you, Catherine and Amy, for an informative presentation, and thank you to everyone for attending today's webinar. If you have additional questions, please feel free to contact me, Morgan Gary, at my email, mgary@bradley.com. Once you leave the webinar, a brief evaluation will pop up in a new browser. We would appreciate your feedback, which will help us with future webinars. On behalf of Bradley, we thank you for joining us today and have a great rest of your day.